Good morning, everyone. I trust that you've all had a wonderful conference yesterday and today, and this panel will be a complement to the wonderful programming you've had so far. So this program, and there will be one of our presenters on screen with us. I actually did not realize there were 6 TVs. Talk about an abundance of television. Civil court can use one of these. So if one goes missing, don't ask any questions. All right. So someone will. Is she there?
Yeah, she did.
Oh, wonderful, wonderful. Okay. So this is the title of this conference or this panel is Justice for Survivors of Intimate Partner Violence: Transforming an Equitable Family Law System. And everything that we've heard so far is valuable to understanding the whole. Right. One of the things that we have to also understand are the decision makers, the judges, the things that go into actually becoming a judge, the training for judges, decision making, and things that keep judges out of trouble, right? And as a judge, I would tell you that's a very important,
Yes.
almost daily assessment, right? So I'm the supervising judge of New York County Civil Court. I'm the president of the Asian Judges Association, and I know I'm at a family law conference. I'm not lost. It's not a civil conference. I spent 2 decades working in family law, matrimonial, and family court. The panelists, we have a star-studded, really stellar panel. That is no commentary to the other panels. In fact, I know many of them, but I will say selfishly, this is probably the best panel you're going to see today. Don't don't leave. You have to stay. But it's just to manage your expectations. I trust you all have the material, so you have full biographies, doing justice to the panelists and really to myself, because we do have a time limitation. I will tell you who they are, and then charge you all to reread, since I assume you've all read them already. Reread their biographies. On screen is Savina Playter, who's an attorney in private practice on the 18B panel and the president of the Bronx Women's Bar Association. I trust you can all see her. Oh, there she is. There's a 7th screen. Forget 8. This tells you how long I've been in government practice, where these big screens excite me. There's also Robert Tabechian, who is the administrator and counsel to the New York State Commission on Judicial Conduct. We have the Honorable Judge Tamra Walker, a family court judge in Queens County, sitting in primarily a CVO, child visitation order protection docket. But if you know anything about family court, you really don't only specialize, you do everything, right? And then last but certainly not least is the Honorable Juanita Bing Newton. Doing justice to myself, it would be impossible to read the judge's biography because we'll be out of time. Simply put, the judge is responsible for training almost every judge who's gone through judicial training and on the bench. So when we talk about judicial training, the knowledge, we really do have the expert on this panel today. So my job is to try to figure out how we can extract all the expertise in the time we have. All right, so we talked a lot about time, so why don't we get started, right? The first topic we're going to get into is, pathways to the bench. At some point, we must be curious as to how judges become judges, right? Like, you don't really just wake up one morning and say, I'm going to be a judge, right? Maybe that's a thought. And when you look at the judges, you think, well, they all look the same in sort of how they got there. But do we know the different ways of how someone becomes a judge in New York City? Well, Judge Kluger is a rigor. She knows the answer. So, Judge, don't give away the answer just yet. But in New York City, there's actually more than one way. So to begin that conversation, I'm going to ask Judge Walker to tell us briefly her path to the bench.
Okay, so good morning, everyone. My name is Judge Tamra Walker. I am currently sitting in Queens County Family Court, and I am going to talk to you a little bit about my path to becoming a judge. So I just want to let you all know that my family court has been my passion. I've been actually in family court for my entire legal career, and it goes back to law school. When I was in law school, I worked for a judge in Kings County Family Court. I was a judicial intern for a judge in Kings County Family Court. Also, when I was in law school at St. John's University School of Law, I was in the domestic violence litigation clinic. And with that clinic, I worked through the assistance of the New York Legal Assistance Group. Shout out to NILAG. I worked with NILAG to help represent petitioners in intimate partner violence cases. And through that, I got the experience to work with the survivors of intimate partner violence and take them throughout the case. And we worked in cases in Staten Island, in the Bronx, and in Queens at that time. So I really became comfortable working with the survivors of intimate partner violence. And I also, while in law school, I was part of the Courtroom Advocates Project with Safe Horizon. And with Safe Horizon, Courtroom Advocates Project, then I was able to assist with survivors in drafting petitions and hearing or going through the cases through the intake process. So I think that all of those experiences and starting in law school really helped me because I felt as the working with those survivors, I felt that the empowerment that they felt when they were first filing that for that family offense petition. I felt how scary they may have felt going into court for the first time. And I also had to experience the other part of the dynamic when cases were adjourned for return of process, and then they decided that they no longer wanted to pursue their case, or they reunited with the offender. And at that point, for me as a young law student, it was frustrating. But now, sitting on the bench, I understand that that's a part of the dynamic for survivors of intimate partner violence. After that, when I became a lawyer, I worked for the Administration for Children's Services, and I started as a staff attorney, and I was in the Bronx Family Court at that time. And I thought being in the Bronx, I really enjoyed because I am from the Bronx, born and raised in the Bronx, go Yankees. And I worked at Article 10 cases, many, many cases, hundreds of cases, and ultimately became a supervisor, being able to train young junior staff attorneys. At ACS, I also worked with intimate partner violence survivors because they were often my witnesses in cases involving the children. And I had to work with them and their attorneys to get them ready for stand, which was very traumatic experience, as you may know, get them ready for testifying, and wanted to do it in a way with patience and compassion in order to not re-traumatize. And as a supervisor, ultimately, then I would train staff attorneys as to how to do that with compassion. After that, I became a referee. And as you may know, referees hear a lot of the custody, visitation, and family offense cases throughout the city of New York. So that experience was also very vital to me. I was a referee for 5 years, and referees, it's also vital for referees to experience training because they are a lot of the people who see the custody, visitation, and family offense cases in family court. Referees go through a very rigorous training at this point. They are trained in all aspects of the Family Court Act, but primarily Article 6, the custody and visitation cases, and they learn how to learn about evidence, witnesses, experts, and really entering decisions on these cases. And of course, the same for Article 8, family offense petitions. But in addition to the training, there's also training in implicit bias, which is very important. And there's also training in the dynamics of domestic violence, including understanding trauma and vicarious trauma. That training is conducted for the referees who are really doing the work of the judge as well. So it's very important that that training is not just for judges, but also referees. Referees also go through observations, which is very important and a very critical part of the training for referees. And that observation includes sitting with judges and other referees and observing the entire process, and not just sitting with one judge who may think or feel one way, but the referees had the very important and unique opportunity this year of seeing different judges throughout the family court, throughout the 5 boroughs, judges and referees. So that was very important for the observation portion of referees and their trainings. So that leads me to 2021. And in 2021, just last year, I was appointed to the bench to sit as a judge in the New York City Family Court. I was appointed by Mayor de Blasio last year, so I think it's still pretty new for me and new and exciting. And of course, since becoming a judge, there was much more training because this is not an easy job, and we have to be trained on all aspects of the Family Court Act. So first, there was some specialized training in family court with just family court judges who trained the new judges. So family court judges and even referees, because referees have such a wealth of experience and knowledge in the especially custody, visitation, and order protection cases. And as well, also there's trainings on implicit bias, and very importantly, especially in this aspect of the law, training on case management, because these cases, they need to move and there needs to be some finality, and these survivors need to know what comes next. So currently, I am sitting in a CVO part, custody, visitation, and orders of protection in Queens Family Court. I've been doing this now for quite some time because I was a referee doing the same thing. And in Queens, the judges are primarily the ones who hear the family offense petition cases. So what happens in Queens, the cases are filed virtually and in person on intake, what's called intake, the initial hearing. And that's when it's really important to know how to speak to survivors. Because like I said in law school, like I learned in law school, this could be their first time that they are hearing or telling their story. Okay, so it's important to listen, have compassion, and also explain the next steps. For example, they may not understand that on the next court date, the offender will be served and will be in the courtroom with them. So that's why it's important to explain that and explain resources that they may have to assist, such as going to Safe Horizon to sit before the case is heard. It's important to explain service to them as to what's going to happen next. So that's what we do. And then as judges, we hear in the Queens the case for the duration.
So Judge, can I just, we're going to get to training in a second. Do you mind if I go down the list to the next speaker? Judge Bing Newton. So what was your path to the bench? If you could take about 2 minutes to do that.
She's been on the bench 1 year and you gave her time. I was there 37 years and you want me to.
It's fresh in my mind now.
We're retired, we're not ancient. So, good morning to everybody. That's, I'm always joking because you have to sometimes laugh to keep from crying, as you all well know in the work that you do. So you find joy where you can. And I love to hear your story because it's the opposite of mine. So I remember where I was 50 years ago today. I was sitting in a law school class where there were the same number of women as there are men in this room today. Do you know how many men are there? 1, 2, 3, 4. We found 5 someplace else. There were 5 women in a class of 350. So my journey, when I hear my colleague Judge Walker talk, I say, wow, how things have changed. All of that stuff she did in law school, I didn't do. Because we did have clinics, we were a progressive school, but all of the things that you take for granted were not there. I heard Judge Ellerin, my mentor, she was any woman who was a judge before a certain day can stand up and testify. She was a mentee of Judge Ellerin. So I was in the commission in 1986 before she was. That's how old I am, old as water. I was on the original Franklin Williams Commission that Judge Troy Weber talked about during Judge Kluger's program yesterday. So that's how old I am. So I have lived through this. I know very little about family court, ladies and gents, but I do know a lot about being a judge. I was a judge for 37 years. I was appointed to the secret court known as the Court of Claims. How many of you have heard of it?
That's an actual question. I want to know
How many have heard of the
seriously,
Court of Claims?
be honest. Court of Claims.
Okay.
Okay, good.
This is a pretty good audience because most people have never heard of the Court of Claims. It is not small claims court. Because that's what most people, when we used to have plates, it said Court of Claims, and most people said to me, oh, you sit in small claims. And I'd say, yeah, sure, why not? Doesn't matter. And I was appointed by Governor Cuomo 1.0. And again by Cuomo 2.0 and Pataki in between. I spent most of my time sitting in the criminal supreme term, but I've sat in matrimonial part. I figure, Court of Claims, you can sit anywhere except family court, but I would listen, and there's a long story about that, but we won't go into that. But I was a trial judge, and mostly I've done matrimonial consent part, the most unhappy group of people you can imagine. And I used to tell them, I have no idea how to do this, but I know how to make a decision. You know how attorneys settle when you say you know how to make a decision? That's the first lesson I learned as a judge. Make a decision, right, Judge Ally?
That's right.
Make a decision, Judge.
That's part of the job.
Walker, yes. Make a decision. Spent most of my time doing administration. I was the administrative judge of Supreme Court criminal term. I was the administrative judge of criminal court following Judge Kluger. I was the first deputy chief administrative judge for Justice Initiative, which is now held by Judge Mendelson. And then I left all of that to go to the Judicial Institute, which was my passion, is education. I think I was the first person in my family who was not a teacher. And so I went back to teaching. And my true passion was realized when I was on the board and participated in and was on the board of directors of a place called the Institute for Faculty Excellence for Judicial Education. And so I think that presents to you the fact that I really an educational geek. My relationship to family court was accidental. My first job while in law school was working with the Legal Aid Society in the Bronx office, because I too am from the Bronx.
Yankees.
Go Yankees. Although we had a divided house, my dad was a Mets fan. And while you're in legal aid, you could have the housing court cases or the civil court cases. I got all of the matrimonial cases. My tool of trade was to go out and buy some Kleenex, because I had all the criers, male and female, and I had a bigamist. Isn't that exciting? So I knew enough to know that I didn't know what to do with it, so I called the boss. The only thing I will ask is, because I always do this, and I know I took too long, Judge Ally, but I have to give homework.
Yes.
I'm in my teacher mode. And so this is what I say about developing curriculum for teaching judges what you want them to know. You must ask yourself, one, what do you want the learner to know? What do you want the judge to know? And then what do you want them to think about what they know? And then what do you want them to do in response to what they've learned? Because if you don't answer those three questions, it's just a nice session with coffee and bagels. And I think the judiciary needs to know what you think on those issues as they develop increasingly more beneficial educational sessions. I'm delighted to be here. This is my first time on public transportation. I wouldn't do that for anybody else, for Judge Kluger. In 2 years, for you, I do that.
So you should know that Judge Bing Newton is there is another there's a current one, but she will forever be known as the dean of the Judicial Institute. When you say the dean, it's only Judge Bing Newton. And that was it still is a very heavy responsibility to train judges. It's ongoing, but you are have the benefit of hearing from the dean. So if you're taking notes, I would take copious notes when the dean speaks. When everyone speaks, when the dean speaks. Okay, so we're taking notes, right?
Point out one item, because Judge Newton was elected to her offices.
No, I was appointed.
Didn't you ever run?
No, never ran. I never belonged to a political club. I never ran, and I will gladly tell you my story of getting to the Court of Claims. I had a benefactor who helped me, and it was the chief administrative judge of the courts, along with the chief judge, because I had worked for them, and they thought I was a hard worker. And an opening came up for 23 vacancies, so there were no incumbents to the Court of Claims, and that's like the mother lode, right? And I said, Judge Bellicosa, do you think I am worthy to be a judge? And he said, I think you are. I will support you. And so I usually don't tell that story because you have to be at the right place at the right time, have the right credentials and the right supporters. And that's not how most people get to the bench. But you never know when you work for the right person at the right time. And if you see an opportunity, go for it, because nothing beats a try but a failure. So you might as well try. So I like yesterday's speakers, I hope the family court sees many of you on the bench one day, because listen, you may have an in with Judge Kluger here. I'm not trying to compromise you at all, Judge Kluger. You will not be compromised. She says she will not be compromised, and that's good. Do you want to talk to the mic? The Mayor's Committee is an open process. It creates outstanding people. The only problem in transparency that I have with appointed people is that sometimes the judges, I think incorrectly so, but sometimes the judges feel that they have to behave in a certain way, not to only do justice to the cases and controversies before them, which is basic, but also they have to be reviewed. And so they can't do crazy things. And, as an administrative judge, I will attest, Judge Kluger, sometimes people do crazy things.
Well,
right?
we're going to
You
hold
want the
on.
mic? Sometimes I have, as an administrative judge, I have said to judges, sit down and answer my question. This is about wellness. What is going on in your life that has you acting this way? When you have a colleague, when you have a family member, when you have a child, when you are supervising judge, you have to sit down, bring it down a notch, and say, please, what is going, Bob Tembekian, I've been on the Commission on Judicial Conduct for several years, no longer, one of my fun jobs. You have to ask, what is going on in the judge's life that has her behaving in a certain way? Because your personal life runs over to your private life. And so we did bring judicial wellness in the courts many, many years ago when it was first poo-pooed. Judge Lippman said, what's wrong with you, Juanita? You're always doing something just out of the box.
No one leave the meeting, because that is going to be one of the conversations. If you leave, you're going to miss a good one here.
So
An
Oh,
unscripted round of applause, by the way. I wasn't expecting a round of applause at that moment.
All I was trying to say was that in New York City, while family court judges are appointed,
Yes.
throughout the rest of New York State, they are elected. And that
Yes.
process is entirely different than the one that Judge Walker had to challenge and master in order to become a family court judge. And often in particularly the lesser populated counties, family court judges are also county court judges and surrogate court judges. They wear three hats, and their time, attention, training, and focus is often divided. And that creates a completely different set of challenges, I think, for litigants and the judges than those who might appear before somebody who came up the way Judge Walker did.
Yeah. So we're going to get into another topic now, but for your edification, right? you might already know this, but we're talking about New York City. So we already see that the mayor will appoint to family court, criminal court, and there's a third exotic, interim civil. I'm not sure how often that happens. It happens, but those are three boxes that have to be checked off. We'll follow this up on how to become a judge panel, which I think you all should attend. So we have the mayor of New York City appointing family court, criminal court, and interim civil. We have the governor appointing court of claims. That's 62 counties statewide, right? And this is in New York City. And then there's a third. And that's the way I became a judge. That's elected. I was elected to the New York City Civil Court out of Manhattan. So if anyone here lives in Manhattan in 2018, hopefully you voted for me, right? It was a close race. I ran uncontested, and I still thought I was going to lose. Countywide, right? And I started my judicial career in criminal court, even though I was elected to civil court. And then 18 months later, I was promoted to supervising judge of civil court. So we are the small claims court. I know we're not court of claims, but I will proudly wear small claims. It's the people's court. We also have housing division and then general civil. But the elected process, Supreme Court's elected as well, and that's statewide. So the elected process is a process all in itself. And to get to that, we're going to turn our attention to the screen now. Ms. Playter, you've been on the screen. I feel like you're trapped in there. We should come and rescue you out of that screen. But in your and there'll be enough speaking points for everyone. So my time limits are just to get all these great questions we have here. Ms. Playter, if you could take about 2 minutes to tell us, as part of a screening panel, whether it's the electoral or the judicial, the appointment process, what are some of the qualities that we're looking for?
Good morning, everyone, and I'm so happy to be here. As Judge Ali said, I am the president of the Bronx Women's Bar Association, and I'm also the chair of the Bronx Family Court Bar Association, and I continue to represent 18B persons in the lawsuit and legislation as we fight for appointed counsel in Raise the Rate. I'm very happy to be here today because in my background, I have pro bono represented Indian women who are victims of domestic violence. I consider this a very important topic in my life, and I'm glad that we have a 2-day conference on this issue. And now I'm going to turn to the question. So I have sat on screening panels representing the Black Bar Association of Bronx County and the Bronx Women's Bar Association to select judicial candidates as part of the Independent Judicial Screening Committee for the Bronx Democratic County Committee. I've also sat on screening panels for the judicial candidates seeking judicial position in the New York Court of Appeals. And the panel, in my experience, is comprised of volunteers from bar and community associations. Typically, panel volunteers are chosen by the president of these organizations, or in some instances, they are judicial committees within the association that may select who will attend and participate in the screening panel. Now, what are we looking for in the screening panel? Now, if you come from, let's say, for example, an affinity bar association, you might be asking questions such as, for the Bronx Women's Bar Association, we'd want to know, how have you advocated for women? If you come from another affinity bar association, you might be asking a question that pertains to that makeup of the membership of your organization to attempt to address some of the concerns that they may have. What we're looking for in the screening panels are really the skills and qualification of the judge. We're looking for temperament. We're looking for, do you know the bar that's going to appear in front of you? How are you going to approach that bar? We're looking for legal skills, knowledge of substantive law, your analytical ability, oral communication skills, of course, legal writing, courtroom trial skills, the strengths and weaknesses of the nominees, your willingness to listen, patience, fairness, open-mindedness, objectivity, firmness, and of course, service to the law. If you're a sitting judge and you're trying to go from the lower court to the Supreme Court, We're looking for your ability to control courtroom proceedings, your preparation, your attentiveness. Can you manage a docket? Your courtesy to litigant, your courtesy to counsel and court personnel. What have been your public disciplinary sanctions, if any? And very important is the quality of your judicial opinions.
Okay, I'll take the pause as being that was your answer. Okay.
Well,
okay,
was my 2 minutes up?
That yes, it was. I have to now start the clock. Yes. You went overtime. Okay. So now we have a logical progression, right? The judges are on the bench, and I can't overstress that it's very important to know, because if you look at the judges, you can't tell, right? But it's important for us to know how judges come on the bench, because it comes with training, experience, right? And that's what we're going to get now. Every judge is an expert on something. Just are they sitting in the court where they're an expert at? Right. And that is, and I see a lot of shaking heads, and trust me, I know my audience, right? That is an issue with judges who are sitting in court that they might not have their expertise. I was in the criminal court. I happen to have criminal court experience, but still, even with my experience, it was still challenging. But let's get to training. Judge Walker started the conversation with training. We're going to get back to Judge Walker, but we're going to start with a dual analysis in training. We're going to start with the dean, right? And by the way, I moderate several panels. The fact that we have such a relationship that we can communicate with one another tells you that's a really good panel, right? That you're not being spoken to, but we're having a conversation together. I say that to say I did not oversell how great this panel is. They really are. And there's an opportunity for question and answer. That's your opportunity. Please take advantage of that. So we're going to start with the dean. The dean's going to give us the front end of training, judicial training, and then I'm going to ask Mr. Tibetan to give us the back end of when judges don't follow, right? Judicial training, what happens there. I'm going to ask Judge Walker to give us the day-to-day training that a judge gets. Ms. Playter is going to give us from a practical practitioner's point of view, her training, and then maybe I'll say a word or two. Okay, that's the lineup. I know what I'm going to get by saying this. Judge, 2 minutes.
Yes, I'm going to stay within 2 minutes while you explain to me dual analysis. You didn't bring that up in our sessions. I think, let me hit some high points. I think judicial education suffers from a lack of input of money and time. When I became the dean of Judicial Institute in 2009, they had new judges school, and it was in December. And it's an interesting notion because who could come in December? It was designed for those people newly elected throughout the state. It really wasn't designed for everyone else, because most family court judges in New York don't even know they're going to be judges and start until January, right? And so the first thing I did was speak to the chief administrative judge and say to her, I want to move new judges school from December to January and make it mandatory. It was be your first assignment. And she said two things: how many people and what's the cost? And I said, of course, I have no idea because I just got here. But it will be worth it if you think about the pedagogical value of bringing all the judges together. One year we had as many as 100 people, which was not what she expected. And we had the attending cost because we brought everybody into the Judicial Institute for a week. Now, a week is not enough to learn how to be a judge, because you have to realize that being an exceptional lawyer does not mean you'll be an exceptional judge. It just means you've been an exceptional lawyer. And so our focus was to put as a curriculum item how to be a judge. Because Bob will tell you, Mr. Tembekian, I know him so well, I'll call him Bob, will tell you that many of the faux pas that judges make, and I don't want to say sanctionable action, but faux pas, comes from not really understanding their role and overstepping that role. And so we want them to learn how to be a judge. We want them to learn the tools of a judge, evidence, for example. Have you been frustrated in a trial because the judge doesn't understand the rules of evidence? That a lot of judges do not understand the rules of evidence. That's on my list of what do you want a judge to know and how you want them to use it. Many judges don't have the clue as to the importance of administration, except the Fund for Modern Court this year with respect to the chief judge's position that's open, has stated they think that the screening panels should consider the administrative ability of any candidate before they come out of the panel to the governor. This is the first time I've seen such a public understanding that judges have to manage their court and manage their dockets. The items I put there for your consideration that I think judges must be taught are the rules of the chief judge, which says, interestingly, there are very few things that we are statutorily required to teach, and they are all related to domestic violence. Secondly, yes, in two respects. Secondly, the rules of the chief administrative judge, which are the Mr. Tembekian's rules, the rules of judicial conduct. You need to start with the fundamentals as a judge, so we want them to know that. And thirdly, I added something that I thought Judge Weber referenced yesterday about having a rule of civility. There is already in Part 1200 the rules of civility of the court. Judges should read them. Counsel, you should read them, because we found, Judge Ellerman told you yesterday, we found that women are undermined more in court by fellow counsel who are male than by judges, which is an improvement from 1986. In 1986, everybody was rude to women, but that's okay. There has been progress, my dear friends, since 1986. And so we have a combination of things that we want to teach the judges, both concrete, like how to run the court, knowing the rules of evidence, fundamentals like ethics, which are the foundation. And then, of course, we treat other topics such as domestic violence and implicit bias. And we've been doing that since 2009, and I hope they still do it with rigor. But someone yesterday said something that I thought struck me as I watched it. She said, you can train as much as you want. You have to have people who are receptive. And so I think that one of the things we try to do in judicial education is by our demonstrative ways, have people know that things and what's acceptable and what's not acceptable. So I'll tell you how I learned about domestic violence. 1975, September, in Archie Gorfinkel's part in the Bronx, Part 1E, criminal court. There was a domestic violence misdemeanor case, husband and wife, but the husband punched out the cop, so there was a resisting arrest. I was busy with all the other cases in that part where there were about 75 cases, and I was working alone. And as the judge called that case into the record, and I was not paying attention, he reamed me out publicly and said, Miss Bing, don't you ever treat these cases in such a cavalier manner. And that changed my attitude about domestic violence cases. I was forever receptive to what we needed to learn about domestic violence. And I think that's a real important thing that young lady, the panelist, said yesterday. And I wish I could attribute who it was, but I don't remember. But it struck me that we have to get people receptive to what we are teaching them. And lastly, a caveat. When we teach any issue, we have to teach judges how to be neutral magistrates. And some of you may wonder why when you invite a judge to a program, she doesn't come. That might suggest the judge is not interested or is hard-hearted. But we have some suggestion from the Advisory Committee on Judicial Ethics, some from the Commission on Judicial Conduct, that says that judges may not go to trainings that are geared to one side and not another in an adversarial proceeding. So before you condemn the judge for not coming to your wonderful program, question whether or not this is something he or she can attend. And that's more than 2 minutes, and I have a lot more to say, but I defer to you, Mr. Administrator, panel leader.
Judge, panel leader, my resume just was updated to include panel leader on that. But I will say, I'm gonna move down to Mr. Spetchin, but the judge mentioned many things that are worth noting. The one that now that I'm an administrator, that good judges have to be managers and administrators as well, right? How many of you have been part of a courtroom where it was not managed well and becomes very frustrating and it affects the case? Spent 20 years as a litigator, I will tell you that is a key component of judging, right? And I love the line that training is only as good as the receptive nature of that training. Excellent, excellent line. All right, so we got the front end of training, right? What training should look like. Now, maybe the back end. What does training look like when we don't adhere to it, Bob?
Well, I suppose my part of the program, in part, is having heard now how you become a judge, is how you leave the bench
Leave the bench.
involuntarily. The Commission on Judicial Conduct is the state entity. It's created in the state constitution that has the responsibility to receive and investigate complaints of misconduct by judges. There are 3,500 judges or so in the unified court system throughout New York State. And when a judge violates or appears to have violated one of the rules on judicial conduct or the code of judicial conduct, there is recourse. Anyone can make a complaint to the commission, and if on its face it credibly presents information to suggest that a rule was violated, we can investigate and, where appropriate, formally charge the judge with misconduct, and in appropriate cases, publicly admonish, censure, remove the judge from office, or in situations where the misbehavior was less egregious and didn't warrant public action, to confidentially caution the judge. It's important to say a word about what the commission is not. It is not an appellate court. It is not a place where a decision or a ruling, interim or final, can be appealed. Even if we were to determine that a judge in a particular case ruled a certain way because of bias, prejudice, conflict of interest, or otherwise, warranting the most egregious discipline we can impose, removal from office, that still doesn't have any legal effect on the case itself. You have to resort to the appellate courts or move to re-argue, or in some other fashion, according to law, through the courts, redress what might have been the injustice in the decision in your case because of the misconduct that motivated it. But if you conclude or have reason to believe that a judge in a family court or any proceeding has violated the rules, was impatient, discourteous, didn't afford the parties the opportunity to be heard, had a conflict of interest, and I would commend to your attention the rules on judicial conduct, which are they're available on our website, they're available on the court system website. It's 22 NYCRR Part 100. It is a very useful document for lawyers, litigants, and particularly judges to be acquainted with, because it's violations of those rules that we impose. There are a couple of cases, and they really just represent a small slice of the kinds of matters that the commission has publicly disciplined judges for. Our website has all of the 900 plus cases since 1978 that have resulted in public discipline, and they are very interesting reading because they get into detail both in terms of the facts and how those facts violated the rules and why certain sanctions were warranted. But there was one of the cases in the materials involved a judge who really didn't understand his role in a family court proceeding. He was not the social worker. He was not the advocate. He had before him an individual, a young litigant who had a drug problem, and judges are not without compassion, and they're not without interest in what happens to the people that are before them. But this judge took the unwarranted and the very unwise step of taking this young man out for a private conversation at a beach nearby, in order to just, in his view, acquaint him with the fact that he was sympathetic, the judge was sympathetic, empathetic, um, but he stepped out of the role of the neutral magistrate. And even if that conversation ultimately may have been helpful to the individual, it compromised the judge's role as the impartial arbiter of the issues before the court. And that was something that should not have happened. Something else, one of the other cases that is in the materials involved a judge who thought in a family court proceeding, which can be probably the most volatile settings in our panoply of courts in this state or in any state. It's a place where more often than not, nobody is happy coming in or walking out, no matter what the result of the case may be. Not the participants, not the litigants, not the children in custody issues. There's almost nobody who's happy walking out of a family court proceeding. But it's not the role of the judge to make light of the circumstances or the litigants who are before the court. So in one of the cases in the materials, the judge was theoretically, in his own mind, trying to lighten the mood by making fun of the image of a turtle that was on the sweatshirt of a young woman who was one of the parties before the court. And he was making scatological references to what appeared to him to be something that resembled a phallic symbol on the turtle of the sweatshirt. And it humiliated the young woman. It certainly didn't fill her with enthusiasm for returning to the court, and it utterly destroyed the judge's impartiality, and it revealed, among some other things, that this individual was really unfit to be a judge. There's another case which, and as I said, all of these are on our website, and I would urge you to look at this one too. It's not a family court judge, but it was a domestic violence situation. It happened to be a town court justice. The name of that case is Romano. It's not in the materials, but look for it on our website. The judge in this town court was arraigning the defendant in a domestic violence situation, and he made what he thought were jokes about the domestic violence situation, including saying, well, what's wrong with this? After he read out the charges, you have to keep these women in line. Now, not only the defendant, but the victim was in the courtroom. And even if they weren't, it evinced a cavalier attitude toward the seriousness of domestic violence, toward the victims of domestic violence. And regrettably, it encouraged the defense lawyer to make another joke, so-called, about the place of women. And that judge was removed from office. It wasn't a family court judge, but it was the kind of situation that a family court judge could confront. I don't believe all the training in the world would have changed the attitude of this particular judge, but to the extent that training might have acquainted successors as to the consequences of that kind of behavior, you will lose your judgeship if you make that kind of remark in court, does have, I think, a significant mitigating effect on behavior. And it forces the new judges to think about how their words and their actions are perceived. Everyone laughs at the jokes of a judge, whether they're funny or not, because in the courtroom, you're sort of trapped. And if you don't laugh at the judge's joke, then it's probably going to be detrimental to your client. But what some judges think of as humor is not very funny at all. And there is a place that you can go when you confront these kinds of outlandish circumstances, not as a means of forum shopping, because even if you make a complaint against, so we can't take the judge off your case. And there are advisory opinions that say that the judge doesn't have to get off the case unless we at the commission have formally charged the judge with misconduct. So we're not a place where you can go to get a new judge in your case. But we are a place where you can get some redress for these kinds of egregious misbehavior that unfortunately, for all the benefits of training, continue to occur and will always occur. And it's one reason why we've constitutionalized the disciplinary system here, so that it will be around for as long as there's a judiciary.
Okay.
Judge Ali, can I
yes.
just, a footnote, please?
Yeah, of course.
Many of the people you appear before are not judges, i.e. support magistrates and referees. They are employees of the unified court system, and they can be subject to disciplinary action through the administrative judge, and certainly complaints can be sent to the inspector general of the unified court system. And Judge Ali, you're in a supervisory role now.
Yes.
Any update to that we want, so that the people can know where to send their complaints?
I think starting at the supervising judge level is always, trust me, I get them all the time. It's usually a good start. It also helps administration know that something might not be happening or something is happening. Unless you have someone who's in the courtroom with the jurist at all times, which is not possible. We rely on feedback. And I think as everyone has said, not every complaint turns into an action, but you should that's your step, right? That's as much as you can do. You could raise this and then the action comes back. Judge Kluger?
And that would,
go ahead.
I was going to say that would apply to non-judges who are applying for appointment as well. So that if you've had a negative demeanor experience with, a support magistrate or even an attorney on the other side who has now applied to be a judge, that should also be referred to the mayor's committee in the appointment process, because as you heard from Judge Walker, there's vetting that goes on.
So
You're right.
Right.
to some, I'm sorry.
I just want to say something that yesterday troubled me. I listened very carefully. And the notion that you will not report an egregious act or behavior because you fear retaliation is something you just have to eschew from your life. You have to be advocates, but you have to be warriors in some respect. I read the Jay Johnson report and said it looks like the report we issued in 1991, and a lot of it was based on people who tolerated behavior because they thought they had to. They wouldn't get promoted. They wouldn't get reassigned. They wouldn't, whatever. But I think, we can't change anything if we don't know about it. If the mayor's committee doesn't know about it, a bad judge is going to be maybe reappointed. So I know it's hard, and I know you have to pick your battles, but I hope that that's not a general feeling that none of you will report behavior that should be reported. Find somebody else to report it for you. Let's be creative. I'm serious. If you think it's going to hurt your client, be creative advocates. We can't permit the bench to be filled with people who are inappropriate.
So to summarize, Judge Kluber, just because you weren't using the mic for those and this is a really high level summary. The mayor's process will take any complaints. Please reach out to the mayor's process. It's confidential, and that would be part of the vetting. And if you don't reach out, there's no way for it to be known, right? I think I summarized that. Okay, so for Judge Walker and Ms. Playter on the screen, I know I put you both in a tough position because now you're both going to have to answer from the practical day-to-day point of view. Right, Judge Walker, you're on the bench. You handle a CVO docket, but it's not fair to say only a CVO because child protection cases come in with those types of cases, child support, juvenile delinquency. It's quite often to have I haven't been in family court 4 years, but I don't think it's changed. The kitchen sink type of cases where it's only one family, right? So you can't separate them out. How do you keep yourself up to date with the law, and especially when it relates to intimate partner violence? And Ms. Playter, I'm going to ask the same question for you, but in a different context. Okay, so you're up next, Judge Walker. You're up.
Okay, so first, when I talked a little bit about it, but when I was first appointed, right away we were given training on all aspects of the Family Court Act. So at that point, I had been presiding over the custody, visitation, and family offense petition cases as a referee. But there was more detailed training regarding Article 10, child protective proceedings, juvenile delinquency proceedings, child support even, and really how to manage your calendar. And further, as Judge Bing Newton said in the beginning of the year, now the Judicial Institute, there is training for all of the state new judges. And that was very helpful. And also for that, there was breakout sessions for family court judges. However, there was for all judges an overall encompassing domestic violence training and implicit bias training and case management training. And every summer at the Judicial Institute, there is ongoing training for all judges for the summer session Judicial Institute. So I think that I know that there is ongoing training for judges. There is continuing, the Office of Court Administration is continuing the conversation for the dynamics of domestic violence. And also there's mandatory implicit bias trainings for all court staff, because it doesn't, treatment and with dignity and respect doesn't just start in my courtroom. It starts when they walk into the courthouse, when the parties, the families, the people that we serve walk into the courthouse. So everyone that they come across has to know how to treat others with dignity and respect and avoid any bias, because that's not the court system that we want to promote.
Okay. And Ms. Playter, what do you think?
Well, I think I'm going to talk about the screen and panel first. So there isn't like any formal training that attorneys who sit on the screen and panel have. So what they're bringing to the screen and panel is really like their years of experience, their expertise, whatever practice area they've been in, whether it's family, criminal, federal or state court. And they're able to gauge from a practitioner viewpoint what they're seeing in the courts vis-a-vis the judges and how to gauge temperament. Now, in terms of what kind of training the attorneys have, I've been sitting in family court for many years, and as the president of the Bronx Family Court Bar Association, one of the ways that we were able to obtain training for ourselves and share training across the city and state is the Bronx Family Court launched a series of order of protection CLEs. And it was tremendous that there were so many practitioners and referees and judges who attended. And this was in response to the COVID increase in order of protection cases, as we all know who practice in family court. And it was very helpful.
I've actually attended some of those trainings through the Bronx County Bar Association, and those were very helpful, especially when they were virtual throughout COVID. That was very helpful for all jurists.
Yeah, great suggestions. So I'll add 30 seconds and tell you this. There needs to be interdisciplinary trainings between the judges and the courts. So when I sat in criminal court, I sat in a domestic violence part. It was almost impossible to be a domestic violence judge in criminal court without knowing family law. And it's impossible to be in family court without knowing the criminal aspects. There was a badge of honor for years where a criminal court judge would say, I don't know family law, go to family court. And a family court judge would say, I don't know criminal law, go to criminal court. But it's the same family, right? So those families like, wait a second, someone has to know something. So there has to be cross training. And now I sit in civil court. So I thought I'm done with criminal and family, right? But we see it every day, but you might not know how we see it. Name changes. We see, I've reviewed so many orders of protection and transcripts on name changes. So now I'm training my civil court judges on aspects that they probably have not been trained on. Okay, so here we are. We're coming up on 10 minutes, right? Until the panel's over. So I'm gonna take moderator privilege. I just created that term and institute a lightning round, right? Judge Big Newton's gonna give me a talking to about lightning round. It's just another way of me saying a time limit. I'm just trying to figure out how do I get myself out of the judge's crosshairs. So I have a question for each of you. Ready? Lightning round. Judge Bing Newton, what recommendation to the dean to improving training, including more training for intimate partner violence and domestic violence, informed in the bench?
Stop treating it as a specialty, a specialty part. There was a lady yesterday said, they didn't listen to my domestic violence complaint because I wasn't in a domestic violence part, and therefore maybe I wasn't worthy. Domestic violence can be in a contract dispute. It can be anywhere. And so we should not have these specialized domestic violence training for domestic violence judges. We should have domestic violence training for all judges, period.
Judge Bing Newton gets the award for the most round of applause on a panel I think I've ever moderated. I don't think this ever happened.
I
Bob,
speak for my people.
you speak from the heart. Bob, it's almost unfair for you to follow up. In fact, if you can give Mr. Betchen a round of applause after his answer, I think that'd be only fair. And this comes from the audience question. So thank you very much for submitting your questions. This is great. Mr. Betchen, what happens when you receive a complaint is filed? Is there access? Does the public have access to the complaint? Is it only the findings? What happens at that point?
The public does not have access to the complaint. Any complaint that comes in is going to be reviewed and analyzed, and then it is going to be considered by the entire commission. So it's not disposed of at the staff level. And if we investigate the complaint, we will be interviewing witnesses, looking at transcripts, reviewing other documentary evidence, and so forth. The entire process under law is confidential until the judge is disciplined publicly, and then the entire record of that proceeding becomes public retrospectively. While it's going on, it is not public. Round of applause.
Round of applause, please. Listen, it's hard work up here. Sometimes you got to create your own buzz. I'm certain. Listen, I'm elected. You have to create.
Someday I'll say something applause worthy.
You have to create your own buzz when you're elected. So let's talk about the elected process. Ms. Playter, the elected route seems to be in the hands of political parties in each county. As the kids will say, no lie is detected with that one. How do we? Right, the kids say that, right?
Suppose.
How do we place the power in the hands of the voters? What should the voters be doing to learn more about the judges?
Well, I think that during the COVID pandemic, when judges were running, an important process started to happen. And that is in at least the Bronx County, there were several forums where the judges were able to answer questions. And I think that several judges appeared for interviews, and folks in the community were able to submit questions about child support, about the running of the courts, about moving cases along, the high volume of cases. And I think that we can continue that process. I think it will be very helpful to the community.
Okay, we'll keep the trend going. I will tell you, as an elected judge, at the time you get to the ballot, the decisions are this is in New York City. I'm not talking about the state. The state has contested elections. In New York City, for the most part, we do have contested elections, but it's a process, right? And until they change the process, we have to work within the process. So be proactive at the very beginning of it. When I said I ran unopposed, it wasn't because no one else thought at that point I want to be a judge. Also, it takes a lot of work, but it's a lot of front end work. So you should be involved in the front end as well. All right, and Judge Walker, the question becomes that of, you're on the bench, you're a family court judge. I happen to be married to a family court judge as well. It is grueling. It is grueling. I am lucky. This is being broadcasted, right? I am very much lucky to be. And it is grueling. It is a nonstop 9 a.m. to 4:30, 5 o'clock day. It's like Groundhog's Day, which repeats every single day, right? What do you do to stay well, to keep yourself grounded? And you're dealing with very heavy subject matters. It's not light at all. I mean, you walk through the door and it must be something that takes a toll on you. Maybe I'll have Judge Newton chime in as well about judicial wellness. What do we do?
So I think that what's important is to really have open lines of communication with colleagues. I know that supervising judges are also very important to talk to them if we're having any issues, talk about cases, about any conflicts that you may be having. And I know in Queens, especially, the supervising judge has an open door policy in order to hear from us if we're having any any wellness issues. We want to talk about it or vent about it. And there is a judicial wellness committee, and we were trained at the Judicial Institute about that committee that we can always reach out to. For me personally, I go for a run. I run a lot of miles to clear my head, but it's a very difficult job. We see and hear about a lot of difficult aspects of life, and this is people's lives, and we have to take it seriously. So it's hard sometimes to not take it home, but we know that it's for the greater good, and we have to move forward because we have a job to do, and we have to maintain our sanity in order to keep doing that job.
Yeah, all right, there we go. Thank you. Time now. Okay, it's time. Okay, it's there we go. Thank you. All right, the moment you've been waiting for the last 80 minutes. Your CLE code 4512, and I was told it has to be twice. 4512. Okay. And Judge, so we spent a good amount of time talking about what judges are not supposed to do, judges who are not behaving. But I will say, for the most part, 99% of our judges are hardworking judges who care about the law, care about the litigants that they're before. We do highlight the ones that are not, but we do have hardworking judges in our family court, and I think that Judge Walker here is a great example of the judges in our family courts. So we have 3 minutes for closing thoughts. Right, Ms. Playter, I'm going to begin with you. 30 seconds for your concluding thoughts, your summation, if you will.
Okay, well, I'm going to use my time to talk about diversity. I think that diversity on the bench is an essential component. It's important to have a fair and impartial judiciary. I think that having a diverse bench brings a a different level of experience and these perspectives to bear, they really allow judges to make better and more informed decisions. But more importantly, it also increases the public's confidence in the judge's ruling.
Right. I like that theme. Let's keep that going. Judge Walker, diversity on the bench.
Yes. So yeah, I believe that diversity in the bench is an important factor, and not only just diversity in, but among women, color, race, gender, and expression, identity. I think that diversity of experience is important. Diversity of where you're from is important, and cultural diversity, because especially with the type of cases that we see, there's oftentimes cultural components in how the parties that appear before us may behave. And to just have that experience and to recognize that, and to recognize to hear these cases without judgment, if you will, but with not biased, and really recognizing that everyone has a different background, that's important.
Bob?
Well, it seems to me the courts, like all large institutions in our society, are usually behind the curve. But in the 40 years or so that I've been doing this kind of work, I've seen a dramatic change in the diversity of the bench. And I think Judge Bing Newton's earlier observation, just on the gender breakdown alone, is worth underscoring. But to the extent to which these large institutions catch up to society, it is only for the better to have the institutions reflect the communities in which they serve and to whom they serve.
And for the last word, Judge Bing Newton.
To ask me what I think about diversity is like asking me, what do I think about breathing? It's something that it's wonderful to see that we embrace. And I like to reflect back 50 years ago. 50 years ago, we would not have seen this. And so I think you should all be proud of the fact that change is not going to come. The change has been coming and continues, and that there's hope that there will continue to be change, because there has been change. You just have to keep your foot to the, I was going to say pedal to the metal, but that encourages speeding. So I just keep yourself focused, because the good that you want to do, the good that can come out of a court system that I believe in, and I hope you do too, will come with the advocacy and the courage that you exhibit. And so we have to thank people like Sanctuary and all the other list of people who are involved in this tremendous conference.
This panel began by me telling you it was going to be a great panel, and it's going to conclude by me telling you this was a great panel. And thank you all very much for your time.
I just wanted to thank this panel. I am biased because this was my panel that I planned. And so thank you. And thank you to our guest speaker, Judge Kluger. We really appreciate it. And I wanted to say that this is why we were brought here today, to hear from you, Judge Bing Newton. You were fantastic, as well as all of the other panelists. So thank you for coming out, and thank you, Ms. Playter, for being here and giving us your knowledge. We really appreciate you. So thank you once again. And a round of applause for everyone so nobody feels left out.
Thank you. And I understand some people actually have to get back to the bench, I think. So I'm going to let you guys can get up if you need to. I'm giving housekeeping items, but I understand that there's some appetite, particularly online, for a few notices about the CLE. So first of all, okay, so today and yesterday were hosted by two different fantastic and generous law firms. And they're fantastic and generous CLE departments, which are actually run by people who have to process the CLE. So first of all, I want to thank them, because they really are there's a huge influx of work for them. So thank you to them. I don't know if they can even hear me, but wherever they are, thank you to them. So that means that the process for submitting your CLE is different for the 2 different days. We've been announcing it. It's in the HOVA app. For those in person, it's not as big a deal, but for those online, it is, you have to be aware. Today's, the link online for Gibson Dunn, today's, day 2's CLE for those virtual expires in 1 week. So you have online certificates to submit, and those expire in 1 week. So you have a week to hand them in. Second of all, several people have been asking about the posting of the videos for all of the sessions from today. I understand. Oh, awesome. I understand from also our fantastic special events coordinators and our fantastic Jeff, he's in the corner back there. Everyone give a round of applause to Jeannie and Jeff, who have been making this all happen. I understand that probably the videos will be posted by Tuesday and Wednesday at the latest, and they will be spliced and diced down into individual panels, which also takes human work. So thank you to the human work that goes into that. Speaking of human work, I also want to thank, and they're not actually in the room, so it's a little bit self-involved, but I wanted to thank the staffs of this firm and the firm yesterday who are keeping us fed and keeping things clean. And so I just want to take a moment to thank them. They're not here, but I'm thanking them anyway. Maybe they're listening. And okay, so lunch is from 3 seconds from now and 1:25. 1:25, Mylan Dinnerstein will be back to introduce Judge Edwina Mendelson, who we all know and love, and who's going to be talking about the implementation of the Jay Johnson report, and the gender fairness report, which we heard so much about throughout the conference. So please come back. You have an hour, and I'll see you then. Bye.